Rivers State House of Assembly has frowned at the continued stay in office of the Caretaker Committee Chairmen despite a judgment of the Supreme Court declaring them to be illegal. At the plenary on Monday, the leader of the House, Major Jack, informed members of the certified true copy of the aforementioned Supreme Court judgment in his possession, which he laid bare before the Speaker. Debating on the statement by the House leader, members condemned and berated those they described as impostors and warned all banks, traditional rulers, governments at all levels, non-governmental organizations, and those doing businesses in Rivers State not to transact any business with unelected individuals parading themselves as caretaker chairmen. Commenting on the House leader's statement, the Speaker, Right Honorable Chike Amehule, averred that more worrisome is the fact that these individuals not known to law go to banks and withdraw monies meant for the local government councils for wanton squandering in the name of non-existing caretaker committees. Speaking further, Right Honorable Amehule urged the police and other security agencies to swing into action and arrest the impostors to avoid further breakdown of law and order in the state. Right Honorable Amehule emphasized that the 10th Rivers State House of Assembly, in accordance with the provisions of Section 7, Subsection 1 of the 1999 Constitution of the Federal Republic of Nigeria, as altered, only democratically elected officials to manage the local government councils, adding that the Section 64, Subsection 1 of the Rivers State Local Government Law No. 5 of 2018 further empowers the House to give directive that only democratically elected officials should pilot the affairs of the councils. Reiterating the position of the House, the Speaker stated that the House would not fold its arms and condone the crass disregard to the law of the state and the judgment of the Supreme Court of the land by some impostors. Honorable Lan.
Yes, Choma.
What is your immediate reaction to this?
Well, Choma, thank you very much for this particular issue. I would like to go straight to the point as it is, because it is regrettable, and laughable at the same time that having acknowledged that because of the verdict of the appeal court saying that all parties should return to status quo, not derecognizing the Honorable Speaker of the 10th Assembly in the person of Right Honorable Victor Kojombo, who swore these caretaker committee members in. It is one thing to have a law, and it's another thing to interpret the law. The 1999 Constitution as amended actually did not make provision for interpretation of the local government to forbear within the hands of the local government council. Rather, he enshrined that responsibility on the status of assembly. And you also agree with me, based on what the 1999 Constitution as amended, has made, most of the states, even before the Supreme Court judgment, on local government financial autonomy, was, released a few days back. Most of the states have already included that clause in their state laws, just like the River State's law, Rule 5, 2018. It states categorically that in the absence of local government, elected local government chairman and officials to continue in micromanaging the affairs of the local government, that a caretaker committee ought to be established or inaugurated to manage the affairs of the local government within a short term while the local government elections are made available. And you will recall as well that even before the Supreme Court judgment, the governor of the state, His Excellency Samuel Posenibo Siminalayi Fubara, has already informed through the RISEC, has informed the good people of Rivers State that the local government elections will be coming forth, I think, if I'm not mistaken, on the 5th of October. And when the tenure of this former local government chairmen, elapsed on the 17th of June. The governor congratulated them and, I accorded them and eulogized them for some of them, the jobs they did so much, which I can also recognize. There are still some of them that for the 3 years that they were in office, believe me, I will tell you that within the 23 local government, which I am privileged as the pioneer leader of the Observation Project 774, I know details of most of the infrastructures and as well as the deficiencies that most of this local government has suffered within the 3 years that these particular people were in office. Take for instance, if you go to Ikwere local government, the former local government chairman of Ikwere local government, he did some marvelous jobs. When you see somebody who do something right, you give them credit. He did some good jobs in terms of renovating the local government council. If you also go to our Port Harcourt city anyway, you don't see so much apart from the renovation of the local government council and as well as a few markets within the Port Harcourt local government area and some other places. But how about other local government? Take for instance the Kana local government. This is a particular local government that is very, very critical. Kana local government is a host local government to one of the major state-owned citadel of learning, which is the Kensaruwa Polytechnic. But you agree with me that for almost how many years they don't even have light. But now even the caretaker committee that the governor inaugurated, courtesy of Honorable Marvin, you can see the difference of democracy coming to the good people of Kana local government. Now they can even boast of lights, street lights, and the rest of them just within a period of few months. I think, if I'm not mistaken, they've not even been in office up to 2 months. So what am I trying to say? The Supreme Court judgment stated categorically on the definition of the financial autonomy of the local government. And in that particular judgment, the Supreme Court did not say that anybody who has already occupied as an existing caretaker committee should vacate office. Sometimes it's very, very, very painful that people who we expect, who are supposed to be lawmakers, who are supposed to help the people, make laws that are pro-people, who are supposed to help the people, interpret certain things. Because like you and I will agree, the parliament remain the bedrock of a democratic society. And in a situation like Rivers State, where we have a factional parliament led by Martin Chikameule that continue to, misinform the people just because of their personal pursuit. Believe me, is uncharitable to the good people of Rivers State. And I must say it, notwithstanding the fact that their case of validity is still in court. I think that at this moment, what they should do is to look at how they can continue to at least do things that can affect the life of the people that they represent or the life of the people of Rivers State, while they continue to wait for the Supreme Court to determine their validity if they are still members of the Rivers State House of Assembly. Because you will agree with me that the Speaker of the Rivers State House of Assembly, Right Honorable Victor Okojombo, inaugurated this particular committee. And if you go to other states, I will also give you an example. Abia State, for instance, has 17 local governments that are all manned by mayors of these 17 local government. Even after the local government financial autonomy verdict by Supreme Court, most of the states are still operating them, and some of them have already declared interest for the date of their local government election. And you agree that before even the Supreme Court verdict, the governor of Rivers State has already fixed a date in agreement in tandem with obedience to the rule of law and obedience to 1999 Constitution as amended for a local government election to take effect on the 5th of October 2024. So if you ask me, it's not only laughable, but I will only advise the Nigerian police, because when I was listening and watching the plenary, I must tell you that I was so perplexed, and also I felt very, very pathetic for them, because it has made me to understand that for the fact that they've understood that they've lost touch, they continue to see how they can be able to incite people, negatively. Let me say, for instance, according to the statement of the leader of the house, the leader of the house said that these people go about, withdrawing money from the government purse, and as well as go to market. And you remember also that most of these caretaker committee chairmen are even yet to inaugurate revenue committees within their local government. Most of these caretaker committee chairmen are yet to even mandate their people to start, going about to generate revenue. If you go to Obiakpo local government, for instance, Ambassador Chijoki, who was my very good friend, went to the major market there and declared a free trade for 3 months while he's in office. So why do we continue to say that these people continue to impose themselves unnecessarily? For crying out loud, they are not impostors. As a matter of fact, the law has given them right to continue to man the affairs of River State until the 1999 Constitution gave power to State House of Assemblies, and the River State House of Assembly law, Rule 5 2018, stated that in the absence of existing local government chairmen, the caretaker committee ought to take effect. Remember that this was the same law that they tried to expunge when they reviewed the law in 2023.
Hold on.
Okay.
Hold on, Honorable Land. You've said a lot of things.
Absolutely.
You raised a lot of issues.
Absolutely. Absolutely.
So I wanted you to finish your statement, then we'll take your concerns one by one.
Okay.
Now, you've made a case for the legality of the caretaker committee.
Okay.
Right, in River State. Now, you also agree with me that there was a judgment by the Supreme Court. Now, you are saying that the Supreme Court only ruled on financial autonomy, correct?
Okay, are you asking? Like I said,
the Supreme Court judgment was only on financial autonomy of local governments. Is that what you're saying? The
Supreme Court judgment, quote me, ruled on the financial autonomy of this local government and also mandated that finances belonging to this local government ought to be handled by democratically elected officials. And any state that does not, hold on, let me finish. And any state, remember, any state that does not have democratically elected local government chairmen, it affects their own FAC with immediate effect. And also you agree that the Supreme Court, the federal government, after the Supreme Court judgment, and the state governors, the 30 state governors, after the statement they communicate by the governors forum, has come out to say that they are trying to work out, a mechanism within the next 90 days after the verdict of the Supreme Court on how most of these states, if they don't have democratically elected local government chairmen, ought to conduct their elections within those 3 months, and as well as see how they can be able to make sure that finances of this local government coming directly from the federal government can go straight to the purse of the local government, not to go through the state account.
Now, when in one of the judgments of the Supreme Court, I will quote the
yes,
statement.
please.
The judge said, a democratically elected local government is sacrosanct and non-negotiable.
Okay.
What does that mean? And then, if you recall, when the Supreme Court summarized this ruling, it says that that judgment takes effect immediately.
Okay.
The order was with immediate effect. When the Supreme Court rules and says the implementation should be with immediate effect, what does it mean? What's the implication of this?
Chama, thank you very much. I want to, first of all, before I go about, because I wouldn't want us to maybe misinterpret or misrepresent the Supreme Court. You also agree with me that the Supreme Court, like you know, is an arm of the judiciary, and the judiciary is an arm that was established from the 1999 Constitution as amended. And the 1999 Constitution as amended, if the Supreme Court, which is the apex court of this country, gives a verdict that each and every one of us ought to fall in line immediately after such verdicts are read. I also believe that the Constitution of the Federation supersedes whatsoever, because I'm coming, because the reason why I'm stating that is this. You recall vividly that until a court of competent jurisdiction is yet to interpret to the good people of River State what section 109 subsection 1G of the 1999 Constitution has altered, which stipulated clearly, which is supposed to. I'm coming. No. I want to join the issues because you asked a question. I want to make you understand that the authenticity of the validity of Supreme Court cases. Okay.
You are bringing in so many issues.
Absolutely.
I allowed you to extrapolate to really speak your mind. But at this point, we will limit it to the conversation.
Okay, on the local government.
The issue is on the authenticity of the
caretaker
committee chairman.
Okay.
From that particular issue, you have been shooting a lot of bullets at the State House of Assembly. You have addressed the factional speaker. You have addressed everything. You've made cases for your friends that you said that are caretaker committee chairmen, what they are doing and what they are, and the people and the outgone chairman, what they have not done well. It's fine. But now, let us look at the matter, the meat of the issue, and not deflect. Okay. So do not bring section 109 subsection G. It does not have any bearing to the conversation.
Okay.
The conversation is strictly on local government and not on the legislative arm of the government, of the state government as it were. Now, the Supreme Court gave a judgment and said it is to take effect immediately. It is to be implemented immediately. I asked the question, what is the implication of that ruling with respect to its immediate implementation across the states?
Chioma, as a Democrat and as well as someone who is very well aware of what the parliament is all about, I think I want to inform you on certain things. The truth is this: when Supreme Court gives verdict or judgment, or for instance a resolution, is met within the federal body, that
this is not a resolution, this is a judgment
just hear me
of the apex court.
I agree with you, but like I said, when a particular statement like this from the Supreme Court comes, it is binding on all Nigerians, especially when you are constitutionally a member of the state of Nigeria. But now, like I said, the Supreme Court said it takes effect immediately. And when the Supreme Court said it takes effect immediately, everybody ought to fall in line. But the state governors, remember, I want to take your mind aback a little. We had a situation where the Supreme Court as well gave a verdict about 3 years back during the administration of President Muhammadu Buhari, on this same issue. Remember that there were issues that were cited, because before laws go around the whole federation and become sacrosanct, after Supreme Court gives judgment and it goes to the National Assembly, and the National Assembly passes it and backs to the president, and president gives assent, it is now mandated to the National Assembly to circulate the same memo to all the state house of assembly. So that's the reason why I am trying to call your attention to the originality and the powers of the 1999 Constitution as amended, which is also where the Supreme Court derives its power in giving judgment. We are not saying that the judgment of Supreme Court ought to be flouted. No.